Fox News alert. Opening statements now underway in Detroit in the trial of accused underwear bomber Umar Farouk Abdulmutallab, the Nigerian native, pleading not guilty to charges of attempted use of weapons of mass destruction in the failed attack on Christmas Day 2009. What can we expect as the trial unfolds? Let's get our legal panel in on this. Joining me now, former prosecutor Tom Kniff and defense attorney Chad Lewin. Tom, let me start with you. There's a hospital bed confession, not once but twice. Dozens of witnesses, remnants obviously of the explosions on his body, and you've got this video he left behind in which he talks about his suicide mission. You know, as prosecutions go, this is a pretty easy one, but you think it shouldn't even be in federal court. Why?
Absolutely, Greg. I mean, first, let me agree with you. You know, it's a slam dunk. The prosecutors are going to convict this guy if he doesn't, at the last minute, accept a plea like the shoe bomber Richard Reed did. The reason why people like me criticize the thought of giving civilian trials to Islamic terrorists who have no nexus to the USA other than attempting to mass murder our people is that it gives these individuals a soapbox, a stage, courtesy of an American courtroom, the American judicial system, and, oh, by the way, on American taxpayers' dime, to expound, you know, these insane ramblings, their you know, murderous views, right. And you know, it's all, again, it's at our expense. Whereas if you tried them by military commission, like George Washington used, like Abe Lincoln used, like FDR used, it would be a much more limited proceeding. They'd still have their day in court.
But come on,
it wouldn't be a sideshow.
Chad, what about that? I mean, it's clear he wants to make a mockery of the U.S. justice system because all indications are that he demanded to represent himself. Doesn't Tom have a point?
Well, he has a limited point, but this happened over American soil, number one. Number two, you know, usually a man that represents himself has a fool for a client and a fool for a lawyer. But this kid is not a fool. You're correct. He does want to make a mockery of the system. Basically,
why
what
let
he
him
wants
do
to
it?
do.
You don't have to. You could treat him as an enemy combatant and try him in a military tribunal.
Well, that's kind of a moot point by now because they didn't do that. But what I do know for certain is that, you know, now there's a trial. He has the right to a trial. And if, as a defense attorney, if obviously he's trying to do it on his own, but if I had a chance to come forward, there are things I could argue. This is a Nigerian kid that fell under the spell of the holy jihad. And this bomb that he had, let's face it, wasn't even a bomb. It was a firecracker. Yeah. I mean, it couldn't kill himself, let alone blow up a plane.
Yeah, Tom, that doesn't sound like a winning argument.
Well, no, because it goes back, you know, look, you know, factual versus legal responsibility. We all remember that from law school, right? What's going to be relevant here is this is an individual who clearly had the criminal intent. He'll tell you that himself. He committed the overt act in furtherance of the conspiracy, which was supposed to be a terroristic mass murder. And the fact that his, you know, bomb wasn't strong enough to take down the plane is not relevant. It's factual responsibility. What's going to go is the intent and the act.
Yeah, guys, I want to hit one more subject, and Chad, I'll put it to you. They didn't need the un-Mirandized confessions. In other words, the statements he made to two different law enforcement agencies before he was read his Miranda rights. And yes, I realize it's coming in under an exception, but aren't prosecutors creating an automatic issue for appeal? They didn't need those confessions.
Well, I actually, you're going to be surprised by this because I'm a defense attorney, but I actually believe that this is the one limited spot where this public safety exception should come in and that these statements should come in, even though he was not Mirandized. And the reason being is he was on a plane, he had a bomb, even if it was just a firecracker, it was a bomb, and who knows if there were other planes that, you know, in some sort of, you know, big effort, they were going to try to blow people up. So the fact remains that in this limited situation, the safety of our people actually trump individual rights.
And
Tom, yes, they don't need it, but I don't really think it's
not
going to
reading
be a
Miranda rights for 15 minutes.
Because this is just a textbook example
Tom, doesn't that
of the public
underscore
safety
why
exception
maybe it's a mistake to try this in civilian court? Because, you know, arguably they knew immediately what was happening, and under the law they're supposed to read Miranda rights.
Greg, it goes back to my first point. It's the precedent that we're setting. Again, I think they'll get this conviction with or without the Mirandized statements. And even if there is appeal, 2 words, harmless error. But what kind of precedent are we sending out to the people, to our detractors around the world who want to kill us by telling them that, look, if you hatch one of these schemes to blow up our people, we're going to give you the same Miranda rights that a U.S. citizen would get.
We're setting,
it's totally
we're setting a precedent. We're setting a precedent that we're America, and that if you ask for a trial, you get a trial.
All right.
He's going to go down regardless.
Chad
but this
Lewin,
is America.
Tom Kniff.
He pled not guilty. He deserves a trial.
Gentlemen, thank you very much. Appreciate it.
Thanks, Greg.
All right.
Thank you.
The debate will continue to have, Greg. In the meantime.